So today I'm going to talk about some of the new offences that have been created under the coronavirus lockdown. So what are the new coronavirus offences? Well, there's two sources. The first are those that have been created under the Coronavirus Act 2020, and the second are those that have been created under the Health Protection Regulations under the Public Health Act 1984. I'm going to focus on the regulations for the purpose of this talk, but for reasons that will become clear in just a moment, I'm just going to turn to the Coronavirus Act offences. Now, they've been created in three separate areas. So Schedule 20 creates powers and offences in relation to the suspension of port operations. Schedule 21 deals with potentially infectious persons. And Schedule 22 gives power to Secretary of State and Welsh ministers to prohibit or restrict events, gatherings, and to close or restrict access to premises. Now, all of those schedules have offences in their own rights. However, it is the health protection regulations that are concerned with the general rules that we've come to know that characterise the coronavirus lockdown, and it gives powers to the police and other relevant persons to enforce those rules. And it's for those reasons I'm going to focus on the regulations. Now, the full titles of the regulations currently in force in England are the Health Protection Coronavirus Restrictions England Regulations 2020, number 350. They came into force on the 26th of March 2020, and they've been amended once already on the 22nd of April. So what are these rules that I refer to that characterise the lockdown? Well, we all know them, we live them every day. The first, of course, contained in Regulation 4 is the closure of pubs, restaurants, cafes and bars and other businesses. Regulation 5 contains the restrictions on businesses that are permitted to remain open. Regulation 6 restricts leaving home without reasonable excuse. And Regulation 7 forbids gatherings of more than 2 people in a public place. Regulation 8 is concerned with enforcement, and it gives powers to enforce the above rules to relevant person. In most cases, that relevant person will be a police constable, but it also includes a police community support officer, as well as another person designated by the local authority or Secretary of State. Now, compliance with the regulations can be enforced by the issuing of a prohibition notice in respect of premises, can be enforced by a direction or a removal of a person to their home by reasonable force if necessary and proportionate. It can also be enforced by the directing of the dispersal of gatherings of 3 or more people, as long as they're not all from the same household. The use of all these powers must be necessary and proportionate. So what are the actual criminal offences that have been created under the regulations? Well, there's 3. The first is the contravention of a requirement in Regulation 4, 5, 6, 7 or 8 without reasonable excuse. So an example of that could be a pub remaining open when it shouldn't, or it could be a gathering of 2 households in a public place. Secondly, obstruction without reasonable excuse of a person carrying out a function under the regulations. Now, an example of that could be a situation where a constable is attempting to remove someone back to where they live, and that person is obstructing them from doing that. Thirdly, contravention of a prohibition notice or direction or reasonable instruction given to a person under Regulation 8, again, without reasonable excuse. And this applies to a situation where a person has been given a direction or a premises has been given a prohibition notice, and that person has continued to persist in doing what they were doing that contravened the regulations. Those are the offences, and what are the penalties that flow from those? Well, all of them are summary-only offences, punishable upon conviction in the magistrate's court by a fine. However, according to the discretion of the relevant person, the police constable, most likely, they may offer a fixed penalty notice to a person over the age of 18, or 18 and over from the 22nd of April. The fixed penalty notice sum for a first offence is £60. However, that can be reduced to £30 if paid in 14 days. For a second offence, the discount doesn't apply and is in fact doubled to £120. And for every following subsequent offence is doubled again to a maximum of £960. So that's a broad overview of the coronavirus offences, with a focus on the offences under the regulations in particular. And I'd like to end just with some thoughts on how one might challenge a charge brought under that legislation. The first stage is to ask, well, what am I charged with? Is it under the Coronavirus Act, or is it under the regulations? If it's under the Act, which schedule of the Act? You'll have likely seen examples in the news of where people have been incorrectly charged, perhaps under Schedule 21 of the Coronavirus Act, which applies only to potentially infectious persons. You'll have seen examples of people being wrongly charged with that and their conviction having to be quashed. So making sure that the right charge has been brought is in fact critical, as the police have struggled with charging correctly. In the same vein, it's important to check that the right charge is brought under the correct national provision. Schedules 21 and 22 of the Act both have a separate part for England, Wales, Northern Ireland, and Scotland. And the same is that each of the UK nations has their own version of the regulations. So it's important to check that you're being charged on the correct national provisions, and you'll likely have seen examples of that occurring in the national news as well. One example is that in Wales, you can in fact be permitted to leave for exercise twice in a day when you have a particular health condition or disability, whereas the English regulations make no such allowance. And finally, jumping on from the end of that thought, was there in fact a reasonable excuse? It's a defence to all three of the regulations offences and to some of the Coronavirus Act offences, a reasonable excuse. We're all familiar with some of the reasonable excuses given, and the lists provided in the regulations are non-exhaustive. So what constitutes a reasonable excuse will in fact depend on the particular facts and circumstances of the case itself. The College of Policing have produced some examples of what may or may not constitute a reasonable excuse in the context of leaving your home. And I'll provide that in the handout that Colleen can tell you how to obtain at the end of the talk. But it's important to recognise that police have not had an excellent track record in charging under the new legislation, to the point that the CPS have now announced that they will be reviewing every charge brought under the coronavirus legislation. So it's important to keep this under review. That's about everything I wanted to cover. It's been a broad overview of the offences under the coronavirus legislation, and I end with the caveat that, like with everything else, everything is changing day by day, so it's important to keep it under review. Thank you for listening.